Welcome to The Explainer. Today, we're diving into what I like to call Canada's secret estate laws, and we're going to show you exactly how to make sure your family doesn't lose, well, everything. Now, I know, when most of us hear estate law, our eyes just completely glaze over, right? It sounds like endless mountains of paperwork, a bunch of complex legalese, and something you really only need to worry about decades down the road. But the reality? The legal framework governing what happens to your life's work is actually deeply fascinating. It varies wildly depending on where you live, and it's absolutely critical to your family's future. Let's get into it. So let's kick things off with arguably the most critical question. What actually happens to your hard-earned money if you do absolutely nothing? I mean, if you just ignore estate planning entirely, who gets the house? Who gets the bank accounts? You might think the law naturally steps in and protects your closest loved ones, but relying on those assumptions, that is literally one of the most dangerous things you can do. Which brings us to Section 1, the cost of doing nothing. Our very first major pitfall is dying intestate. That's just the fancy legal word for dying without a valid will. And when you die intestate, you're surrendering all of your control. You are essentially handing the keys to your entire estate over to a rigid set of provincial rules that will distribute your assets with zero regard for your personal relationships or your private wishes. A lot of folks just assume their spouse automatically gets everything in this scenario, but the legal reality, especially in provinces like Ontario, is shockingly different. There's this massive gap between what we assume is fair and what the statute actually dictates. If you're married and have kids, the law does not just hand a blank check to your surviving spouse. And if you're in a common law relationship, the shock might be even worse. Let's look at Ontario. A married spouse there doesn't just get everything. They only get the first $350,000. That's known as the preferential share. And then they have to split the rest with the children. If you have one child, that remainder is split 50-50. Got multiple kids? Suddenly, your spouse is down to just 1/3 of the remainder. And for common law spouses, the situation is honestly pretty dire. By default, under Ontario intestacy laws, they receive absolutely nothing. Nothing. They might literally be forced to bring a complex, messy legal claim against the estate just to survive.
And look, it's not just about the money. Dying without a will triggers massive administrative delays, piles on extra court costs, and forces a judge, not you, to appoint trustees for your minor children. The inheritance for those kids is typically locked up by this court-appointed trustee until they hit the age of majority. At that point, they might just get handed a massive lump sum all at once, which, let's be real, is probably not in an 18-year-old's best interest. Plus, you lose the chance to name a guardian you actually know and trust. The court decides who raises your kids. Now, this gets even trickier with separated spouses, because timing and documentation really matter here. In British Columbia, the law excludes separated spouses from inheriting if you die without a will, provided you've been separated for at least 2 years and at least one person intended it to be permanent. But Ontario? They recently updated their laws to completely revoke inheritance rights the moment you separate. They now treat separated spouses exactly like divorced spouses, who already had no inheritance rights whatsoever. Moving on to Section 2, the probate tax trap. Okay, so when you pass away, the government inevitably takes a cut through a process called probate. Essentially, probate is just the court formally confirming that your will is actually valid and that your executor has the legal authority to deal with your assets. But this confirmation, it comes with a hefty provincial price tag. In BC, for example, the probate fees on an $800,000 estate will cost your executor exactly $10,650. That is a significant chunk of change coming right out of your family's pockets. And keep in mind, if you own real estate in multiple provinces, it gets even messier. Real estate is generally subject to the probate fees of the province where it's physically located, no matter where you actually lived. So let's compare the systems. Ontario calls this the Estate Administration Tax, and they charge a flat 1.5% on anything over $50,000. BC, on the other hand, uses a tiered system that charges up to 1.4% on anything above $50,000. In both provinces, the first $50,000 usually triggers zero or very minimal fees. But once you cross that threshold, watch out, because the percentage scales up rapidly based on the total value of your estate. To complicate things further, BC offers this really helpful fee-free small estate declaration for estates under $25,000. This lets executors collect the assets without ever going to court. Ontario, however, they don't have a formal small estate statutory exemption like that. They force practically every estate that needs a certificate straight through the full court process. That means more headaches, more paperwork, and more legal hoops for your family, even if your estate is relatively modest. Let's look at Section 3. Can courts rewrite your will? Now this is wild. What if you actually do have a valid will? You've paid all your fees, and you've laid out your exact wishes. but a judge decides they just don't like what you wrote. Well, depending on where you live, they can absolutely step in and change it. Ontario strictly defends what's called your testamentary freedom, meaning you can leave your money to whoever you want. If you want to completely cut your adult children out of your will in Ontario, you generally can. But BC takes a totally different approach. Under their Wills, Estates, and Succession Act, we call it WESA, courts are allowed to literally vary a will if it isn't, quote, adequate, just, and equitable in providing for a spouse or children. It actually imposes a moral obligation on you, the will maker.
This was a massive shift for British Columbia. Believe it or not, before WESA modernized these rules back in 2014, BC's succession laws were actually based on an English law that was 175 years old. So this new legislation brought the law into the modern era, for sure, but it also granted the courts incredibly wide discretion to enforce these moral obligations, which severely limits a person's absolute freedom to just give their stuff away however they want.
And this leads to some highly dramatic outcomes. Take the Yonge versus Poole estate case, for instance. In this case, a father had twins, abandoned them right at birth, never paid a dime of support, and explicitly disinherited them in his will. But when he died, a BC judge used WESA to literally rewrite the will, giving those estranged adult twins 70% of his entire estate. The judge ruled that because of his lifelong neglect, the father had a strong moral obligation to make up for his desertion after his death. Pretty crazy, right?
All right, Section 4, the digital will revolution. As we all know, technology is rapidly changing how we do everything, including documenting our final wishes. For centuries, a legal will required wet ink on physical paper, signed right there in the physical presence of witnesses. But recently, British Columbia became the very first province to allow completely digital wills. We're talking electronic signatures on a screen in front of virtual witnesses, zero paper required. As of December 2021, you do not need a printed original or a pen. You can literally just share your screen on a video call, sign a PDF with a stylus, have your witnesses digitally sign that exact same file, and save the whole shebang to the cloud. But hold on a second. Before you rush to digitize your legacy, we have to talk about the severe risks. What if the file gets accidentally deleted, or hacked, or secretly altered without leaving any physical metadata fingerprints? How exactly can an executor swear in court that an unlocked PDF wasn't quietly modified by some tech-savvy relative after you drafted it? And hey, if you accidentally drag the file to the trash bin, did you legally revoke your will, or was it just a slip of the mouse? The convenience is definitely incredible, but these digital pitfalls, they are entirely uncharted territory.
Now for the good stuff. Section 5, how to bypass probate.
You might want to pay close attention to this one. The absolute secret to avoiding that probate fee trap we talked about earlier is to route your assets around your estate rather than through it. You can use strategic protections like RSPs and TFSAs with named beneficiaries, life insurance payouts, and property held in joint tenancy. All of these bypass the estate entirely, meaning they totally avoid probate in both BC and Ontario. If you designate a specific person and not your estate on your TFSA, those funds transfer directly to them by operation of law. By just taking 10 minutes to fill out your beneficiary forms correctly, you can instantly shrink your probatable estate by hundreds of thousands of dollars. It is a total game changer. Now, for higher net worth individuals, there's another really powerful tool. If you're over 65, you can set up what's called an alter ego trust. This allows you to hold your assets during your lifetime and then distribute them tax-free when you die. To put that into perspective, putting just $500,000 into one of these trusts saves $7,500 in Ontario probate fees alone. Because the assets are technically owned by the trust and not by you personally, they just don't form part of your estate when you die. This allows for a completely seamless, private, and probate-free transition to your heirs.
Finally, Section 6, taking control of incapacity.
Look, estate planning isn't just about what happens after you pass away. It's also about taking control in case you lose your mental capacity while you're still alive. You absolutely must have two separate powers of attorney, one for personal medical care and one for property and finances. This ensures that someone you actually trust can step in and manage your life if you suddenly can't. The person who decides how your investments are managed doesn't necessarily have to be the same person making your critical healthcare decisions. And if you have assets overseas or run a business, you can even appoint multiple specialized attorneys just for your property.
And a quick note for medical professionals specifically, provincial privacy laws and college regulations actually demand that you appoint a trusted successor in your power of attorney to handle sensitive patient records. This prevents disastrous privacy breaches. If a doctor becomes incapacitated, unauthorized access, or the loss of patient records, under laws like Ontario's FIPA, can lead to some truly severe penalties. So your estate planning has to encompass not just your personal wealth, but your professional liabilities as well.
Because at the end of the day, understanding these hidden provincial rules really is the only way to ensure your life's hard work goes exactly where you want it to. So I'll leave you with this. If the unexpected happened tomorrow, would your family inherit a seamless legacy, or would they inherit a devastating, complicated legal battle? Start planning now so they don't have to find out the hard way. Until next time on The Explainer, keep learning and stay prepared.